The United States has continually grappled with how best to balance the imperatives of national security with the fundamental rights of privacy and due process enshrined in the Constitution. One of the central battlegrounds in this ongoing debate is the question of government surveillance, who can be monitored, under what circumstances, and with what oversight. At the heart of this tension lies a series of evolving legislative and judicial mechanisms, particularly those involving the Foreign Intelligence Surveillance Act, FISA, the role of the FBI and Department of Justice, DOJ, and more recently, reforms proposed through the Renewed Investigative Surveillance Act, RISA.
Thank you, Mr. Chairman. Mr. Chernesky, in your testimony, I'm going to read from it. It says, RISA did little in the form of reforms while simultaneously dangerously expanding the scope of surveillance by changing the definition of what was considered an electronic communications service provider. Could you expand on that a little bit? What are you talking about there that RISA actually did not solve the problem and may have made it worse?
RISA, initially introduced as a corrective measure to address growing concerns over the abuse of surveillance tools by federal agencies, has come under scrutiny by lawmakers, privacy advocates, and legal experts. While it was purported to refine and restrict the scope of government access to private communications, critics argue that RISA did little to curb overreach. In fact, it may have widened the net, dangerously expanding the government's surveillance authority under the guise of reform. Central to this concern is a change in the legal definition of what constitutes an electronic communication service provider. This once narrow classification has now, under RISA, been broadened to potentially encompass nearly any company or entity that handles digital data, placing a vast swath of American digital infrastructure within the scope of warrantless surveillance. In a recent congressional hearing, these issues were explored in depth, with testimony revealing serious concerns about the trajectory of surveillance policy in the UE. A prominent witness highlighted how the revised definition could enable mass data collection from entities that were never intended to fall under federal surveillance mandates.
Thank you for the question, Representative. When we were looking at RISA last year, as a part of the reforms, they included a provision in there that would expand the definition of an electronic communication service provider. Now, this used to be a more narrowly tailored thing to capture data, from these particularized companies, but the way that they expanded the definition would capture a wider array of companies to virtually including everybody, right? And so what you ended up seeing was from the Department of Defense, or Justice rather, they made a promise that they were going to keep their searches for this kind of data a lot more limited. But again, it is still problematic enough that even the chair of the Senate Intel Committee, Senator Warner, committed to trying to get a fix to that. Unfortunately, that still has not gotten done to date. But this is a real serious threat if now virtually anybody that has data on Americans could be subjected to being considered an electronic communication service provider.
So we think the new leadership at the FBI is going to be better in terms of respecting people's constitutional rights. Should Congress just move on from this issue, or should it act?
Thank you for the question, Representative. I think that in light of the fact that administrations can change, I would not want to leave it up for interpretation for a potential abuse underneath a future administration. So I do think that Congress should act to go and fix this overly broad definition of an electronic communication service provider.
Mr. Chair, could you comment on the amendment that Mr. Biggs had in his bill allowed for limited exceptions, yet we were being browbeaten saying that, no, you cannot do this, you cannot pass the Biggs bill because there'll be no way out to be able to get a perhaps bad actor. Would you care to comment on that?
Sure. Well, and a number of reasons were offered for that, and my analysis is that it was all just fear-mongering. I mean, every single objection that I heard was just based on a misunderstanding of Mr. Biggs' amendment. For example, as Chairman Jordan mentioned earlier, the amendment had an exigent circumstances exception, so that if there were a ticking time bomb, the agency could act without getting a warrant. And of course, the amendment allowed for people to consent to searches. So if the FBI thought that somebody was being the subject of a cyber attack, for example, they could go to that person and say, we think you may be the subject of a cyber attack. Could we search your communications so that we can find out who it is and try to forestall it? And that person could then consent. And that's also a well-recognized exception under the Fourth Amendment. So the committee very carefully, and Chairman Biggs very carefully built in the protections that the FBI might legitimately need to be able to conduct searches without a warrant.
So the long and short of it, the Biggs Amendment dealt with what you term the exigent circumstances.
Yes,
is that correct?
It had an express exception for that, and it also exempted metadata searches. So the FBI could actually look to see who was communicating with whom under Chairman Biggs' amendment. It just couldn't actually search the communications themselves.
While the Department of Justice has offered assurances that such powers would be used judiciously, skeptics warn that future administrations could exploit these ambiguities, especially in the absence of clear legislative constraints. The hearing also revisited the controversial case of Kevin Clinesmith, an FBI attorney who falsified evidence in the Carter Page FISA warrant process, an incident emblematic of systemic flaws in surveillance oversight. His light sentence, handed down by Judge James Boasberg, further fueled accusations of a two-tiered justice system and raised doubts about the judiciary's willingness to hold government officials accountable. Amid this backdrop, an amendment proposed by Chairman Andy Biggs aimed to restore some of the constitutional safeguards eroded by recent expansions of surveillance authority. The amendment allowed for targeted exceptions in exigent circumstances and maintained access to metadata, while requiring warrants for more intrusive content searches. Despite its provisions, opponents labeled it as a threat to national security, a claim that supporters refuted as politically motivated fear-mongering. As Congress considers the path forward, the debate over RISA and related surveillance policy is emblematic of a broader dilemma: how to ensure national security without sacrificing the constitutional liberties that define American democracy. This moment calls for careful bipartisan examination, transparent policymaking, and above all, a recommitment to the principles that protect individuals from unjust intrusion by the state.
I want to ask you another question, and I'm not sure if you're going to, you let me know if you can answer it or not. In 2021, the FBI lawyer, Kevin Clinesmith, was sentenced to 12 months probation versus a typical 5 years. Why was that?
Well, it was an unfortunate slap on the wrist, and I'm separately representing Carter Page in his litigation against the department, and I thought it was an outrage that Clinesmith got such a low sentence for such an egregious act of dishonesty before the FISA court.
Who was the judge in that FISA court case?
I believe it was Judge Boasberg.
Yeah, so, Mr. Chairman, this is the same Judge Boasberg that we see regularly in the news these days. The ultimate insider judge here in Washington, D.C., gives a slap on the wrist to Kevin Clinesmith, who misrepresented the information out there to the detriment of, it sounds like, your client, and now is doing everything he can to keep foreign alien criminals in the United States rather than sending them back home. I yield.
Gentleman yields. Chair recognizes the ranking member of the entire committee, Mr. Reskin.
Thank you, Mr. Chairman. A lot of people were willing to give 702 a chance because of the various